Stop.
Mom! Hey, stop! Mom! Hey! No!
On February 1st, 2023, officers responded to a domestic call from a woman who had just been released from jail. She came to report financial theft. What she did not know was that returning home had already made her a criminal, at least on paper. The court order she signed hours earlier listed this address as her boyfriend's protected residence, and the moment she walked through that door, probable cause was established. But the bigger legal issue wasn't the arrest itself. It was everything that had been set in motion before officers even arrived.
What did he steal? He stole... I don't even know the extent of it right now because I don't have my debit account. He could have went into my bank and withdraw money from my bank.
Could have.
No, but he did steal money and I have the receipts for it. But he also could have done more, but I don't know that yet.
So
I do have proof.
What do you have?
While I was in jail, he had my phone in my car. I requested it to be with my mom. I called her multiple times while I was in the jail. She could not find it. It was in my car with him.
Okay.
It was charged more than it was, but when I left, my phone was on 4% when I left, and my phone was on 14 when I got back. Cash App, yesterday, I was in jail at 3:01 a.m. $100 sent to him. $75 sent to him at 7:10 p.m. $71 sent to him at 8:23 p.m.
So y'all share a bank account?
No.
Okay, then how was he able to get hit
He had my phone. He had my online banking. He was able to transfer out of my savings because he had my phone. My passwords are saved on my online banking. And he also went into my email, changed my banking passwords. Security alerts, ICDs. January 31st, I was in jail.
Okay.
So he took money from me and now he has my car at the moment.
From your account?
Yes.
Y'all don't share account at all?
No, we do not share any account whatsoever.
Okay. All right.
And
so
he has my car, and he was not allowed to take my car.
Okay. All right.
He has my wallet and my keys and my social security
he
number
lives here
and my
with you,
ID.
Right?
Yes.
Okay. And you just got released from jail?
Yes.
Okay. What did they serve you at the jail?
We have a no contact order.
Mm-hmm.
And I have not talked to him.
Okay.
They put me on ROR.
ROR. Okay, yeah, I know.
So I don't know. I don't know anything because they didn't give me my papers.
They didn't give you papers, but you signed them because I just got them from.
I signed them, but I don't have my papers.
But
I left them on a bench, and then they said that they couldn't find them.
Okay, well I have the papers. Okay?
I don't.
Okay, give me 1 second.
Okay.
On that paper, it says you can't be within 500 feet of his residence, and this is listed as his residence.
Oh, so, yeah, but my mom and his mom talked, and his mom said that he is going to stay there, and my mom cleared that up with him before.
Okay, I understand that, but that should have been explained to the judge. But right now, what I have on paper, you're not supposed to be here without law enforcement present.
Okay.
Okay.
So what do I do then?
So go ahead, turn around, put your hands on your back.
Wait, what?
They're
arresting me, Mom.
Are you kidding me?
Mom,
put your hands. Hey, you stay.
Wait, no. Please stop. Wait, he stole money from me. You're gonna do this?
He stole money from her.
Okay, man.
Wait, my mom said it was okay for me to come here. Wait, Mom!
Stop.
Mom! Stop! Mom! Hey!
Calm down. Calm down.
Mom!
Gia, stop.
Mom,
Stay right. Her baby lives here. This is my house. This is my
I was
house.
told it was okay. I told the court.
This is my house.
Okay, I'll explain everything to you, okay?
Mom, walk me to the house.
She has nowhere else to go. Where is she supposed to go?
Come on.
Ma'am.
Where is she
You
supposed
need
to
to
go?
put your
explain
hands
everything to you,
behind your
okay?
back, okay?
No.
If you don't do that, you're gonna get an extra charge. Do you hear me? If you don't do it,
Please, I can't.
okay.
Her baby is
My baby's here. Is there anything else I could do?
Let's
Is there anything else I could do? Am I gonna go to jail again?
Look,
Let
I'm
us
still
explain
I'm still going
everything
to
to you.
do a report on what you explained to me.
No, I can't. No,
need
he said he was
an arrest, not
gone.
a
He said he was gone.
Not a report on
He said
him.
he was gone.
An arrest.
Okay.
That's my car as well. I want to press charges against him.
Okay, all right.
I can't breathe. Can I go to the hospital, please?
Relax.
I need an ambulance.
That's my car too. I want him arrested.
You need
That's my car too.
Mom.
I'm the primary owner of that car, and I want him arrested.
They told me that I would be okay coming back here.
Yeah, I
They
don't
told me I would be
understand
okay.
this. He's not here.
They told me I would be okay if he was not here.
He's not here.
Stop.
Look, I'm right here, honey. Okay.
He's not here.
You need to. Let's take
He's
these
not
breaks.
here. Why
Can we
should
go
she be
sit down for a
arrested?
Can I
minute?
speak to you over here real quick?
Yeah, can everybody
No,
just
I
relax
need
for
you.
a
I
minute?
need you for a
Yes, I need to
minute.
speak to you over
Okay.
here. Okay.
No, I can't.
Can everybody just relax for a minute?
Okay, here's the thing, okay?
He's not here.
It doesn't matter if he's here or not, okay?
He's officially hold on, time out real quick.
Okay.
Their lease is up in March.
Signed papers that said
He's out
that
as
you
of March
acknowledge
1st.
that you're not
Okay?
supposed
He has not paid me rent yet.
He
Okay,
said he
it
was
doesn't
gone and
matter,
they-
He
okay?
does not live here in my mind.
They
It
set
doesn't
me up
matter,
for
okay?
something. What is this?
This is our home,
Listen,
my home with my daughter.
his listed address is here, okay?
That
Okay.
doesn't matter.
She,
That
since she
doesn't
was
matter.
arrested last night, she's
He
good.
neglected his baby as well.
She brought me
Can I
here.
speak?
Look,
Okay.
how am I supposed
Listen,
to
I understand what's going on, okay? I understand you're upset, but I gotta
I'm
explain.
very upset
I don't
because
know
this
what
is
to
not right.
This is why I gotta explain to you,
You're
okay?
not supposed to be here.
He
And
lives
you
here,
signed
okay?
papers that
I
This
you-
is
understand that, and I'm sorry
It
that
doesn't
I
matter
did,
if
but
he's here or not, okay?
I
This
can't
is
go
his
back to the
listed
jail.
address, okay,
It
with the
won't be
court.
for long.
I just
Okay, well then
please.
they're gonna have to go to the
It's
courthouse
still listed as-
Oh, I will go to the courthouse.
and
I can't do
get
it,
the no
Ma'am, I can't
contact
do it.
order,
I will
okay,
go to the
amended,
courthouse.
okay? But
You're
right
right.
now,
Right
she
now,
cannot
you
be
are
here.
not.
Now, if she,
Mom,
if
I'm going to jail, Mom.
Come on.
if she,
There-
No, Mom, I'm going to jail, Mom.
For no, there's no reason
Mom,
to
I'm
be taking
going
her
to
to
jail,
jail.
please, Mom. Mom, there's no reason to be taking
Gia, stop,
Stop.
Gia,
Mom!
Gia.
Oh my God.
Can I please be explain this? Can I have my phone, please? Can you put it to my mom?
Yeah. We'll give it to your mom, but you're not having it.
So there's got to be no evidence.
I'm not touching your phone. I didn't delete any evidence off of your phone. This one.
What, can I go to the hospital, please? Can I please go to the hospital? You said I would
Okay.
have an ambulance.
Okay.
I feel like I'm having a heart attack. Can I please?
Can you
Hold on.
spread
Oh,
your
come on,
feet?
come on.
Me.
Can I please go to the hospital? Can I please go to the hospital?
We'll get there.
I feel like I'm having a heart attack.
All right. Put your butt in first. Watch your head.
Ow. Ow.
So first thing I want to let you know, if you do go to the hospital, you can't take anything to drink or eat because they're going to want to do lab work and all that, and it can alter it. But can you step out and stand up so that way we want to at least check your vitals and see what's going on, okay? All right. Yeah.
Can I do them from the front if I have good behavior right now?
Well, that's not my call.
Ma'am, I'm Corporal Cavis. I'm one of the supervisors. I'm on scene now. You just resisted and fought my guys. No. There's no snacks. There's none of that stuff. They're going to check you and treat you. And
I
then
haven't
we're gonna
eaten,
go get
sir.
you. Okay. They'll feed you at the jail.
They didn't
Checking your
though.
pulse.
They're going to check your pulse. They're going to check your stuff. And then we're going to go.
Am I gonna get out of the jail?
Probably not until
Try not to move your
When is that?
tomorrow morning.
around.
So I'll be there. They don't have it in the afternoon. He just told me that they had it in the afternoon.
Then I misinformed you. I apologize.
Is there anything wrong with your heart or your lungs?
Yeah.
What's
I feel like I'm having a heart attack.
No, what medical history do you have?
I don't know. Can I please go to the hospital?
Oh, hold on. Hey,
Hi.
there you go.
Good. And you?
Good.
Can I please go to the hospital? I feel like I'm having a heart attack. I need to be seen.
You have a cardiac history?
No.
Okay, what's making you feel like you're having a heart attack?
I can't breathe and I feel like I'm gonna faint and I have not eaten anything. And I have not drinking anything.
It's your anxiety. Okay.
I want to go to the hospital. That's my right.
It is your right. Absolutely.
Can I please go to the hospital?
She's going to jail.
Hey, so she comes with us and take her out.
What?
It's just going to be tough.
We'll wait and see what they say.
We just got to go to the clinic.
I need to go to the hospital, please.
We're
Can I have these in the front? I promise I won't run anywhere.
We are not denying you going to the hospital.
I feel like you are.
I promise you, we are not denying
Do
medical
you think I'll be out of
treatment
jail in the
and
morning? Do you think I'll be out of jail in the morning?
It's up to the judge. That ain't up to us.
Are you guys gonna document that he stole from me and took my car?
What's that?
Can I see my mom before I leave?
They're good. Yeah. Right. What was that?
Gia, the longer you drag
Yeah,
this out,
well-
it's just going to take longer for you to go to see a judge and all that, okay?
About 100.
I know, but I need to be seen.
So if you really need to be
I couldn't
seen,
get a blood pressure to the
Can I please be seen? Can I just go in the ambulance, please?
No, just have a seat. Right there. Well, we'll figure this out. Have a seat.
Nothing out of the morning. That's the only thing now is just figure out how you want to stand by and we'll see. Well, like I know what you said about when a rider. Right. Right. Yeah. That's the only thing left to figure out.
Are those monkey boots?
Yeah.
Yeah, this whole front part when you have official, they're signing.
She's not going to code out the back of the car?
No. As long as she continues to control her breathing, she will be fine.
Okay. I'm good with that. Hop your slide your feet in real quick.
I need to go into the ambulance.
You need to slide your feet in.
Am I being...
You need to slide
Can
your
I have
feet
my
in again.
rights? Am I going to be able to go to the hospital?
They have medical staff on scene, on staff at the gym.
I need to go to the hospital. That's what I need to do right now. Sir, I feel like I'm going to have a heart attack.
They just checked you out, okay?
Let's examine the constitutional framework. The Fourth Amendment requires that an arrest be supported by probable cause, a standard the Supreme Court defined in Illinois v. Gates as a fair probability, based on the totality of circumstances, that a crime has been committed. Here, officers had a facially valid court order, a named protected address, and a confirmed presence. That satisfies the standard. But the 14th Amendment adds a layer the Fourth Amendment does not due process. The subject stated she signed her release papers at the jail, but was never given a copy. She did not understand the geographic scope of the restriction. Most jurisdictions presume knowledge upon signing, but whether that presumption survives a colorable claim of inadequate notice is precisely the kind of argument a defense attorney builds a motion around, and that motion had not been filed yet. Protective orders operate on a strict liability framework. The question is not whether the protected party was physically present. The question is whether the restrained individual entered a geographically prohibited zone. That principle is consistent across jurisdictions, and officers here correctly applied it. What is worth examining is the argument the subject raised, that her mother and the boyfriend's mother had reached a private agreement that she could return if he was absent. Courts have uniformly rejected informal modifications to court orders. Only a judge can amend the terms of a judicial order. No family arrangement, no officer discretion, and no goodwill understanding carries legal weight against a signed court document. The arrest was lawful. The system that failed to explain the order clearly, that is a separate question entirely. Once officers initiated the arrest, the subject refused to place her hands behind her back across multiple commands. Under the resisting officer statute applicable in most states, the offense requires knowing and intentional resistance to a lawful arrest. The lawfulness of the underlying arrest is not in dispute here. The protective order gave officers clear probable cause. The resistance, however slight, satisfies the actus reus of the charge. Under Graham v. Connor, decided by the Supreme Court in 1989, the force used to complete the arrest must be judged from the perspective of a reasonable officer at the moment, not in hindsight. Physical restraint to complete handcuffing on an actively resisting subject falls within the soft to hard empty hand control range. The force appeared proportionate, but the subject was also reporting difficulty breathing, and that is where the legal calculus was about to shift. The subject made repeated, escalating requests for hospital transport reporting, chest tightness, dizziness, difficulty breathing, and no food or water since her prior incarceration. Two constitutional provisions govern medical care for persons in custody. For convicted individuals, the Eighth Amendment's prohibition on cruel and unusual punishment applies as established in Estelle v. Gamble in 1976. For pretrial detainees, the standard derives from the 14th Amendment's Due Process Clause, recognized in City of Revere v. Massachusetts General Hospital in 1983. Both standards require more than deliberate indifference. Officers arranged an EMS on-scene evaluation. That satisfies the minimum constitutional threshold. The prolonged gap between first request and medical response, however, is the element most likely to be litigated in a Section 1983 civil rights claim. So how did each party measure up? The arresting officers receive a grade of B-. The core enforcement actions were legally sound. They consulted the order, confirmed the violation, issued a lawful warning before arrest, and applied proportionate force. The decision to document the subject's theft report reflects appropriate multi-issue handling. The deduction comes from two areas. The medical response was reactive rather than proactive. EMS was summoned only after repeated escalating requests, not at the first complaint of difficulty breathing. And an audible remark by one officer, made within the subject's hearing, suggesting she within the standard of professional conduct required when managing a distressed detainee. As long as she controlled her breathing, that falls below the standard of professional conduct required when managing a distressed detainee. Corporal Cavis, the responding supervisor, receives a B+. his direct engagement with the subject's medical concerns, his clear confirmation that care was not being denied, and his composed command presence in a volatile scene reflects strong supervisory judgment. The subject receives a C+. The circumstances that brought her to this address were genuinely sympathetic. Her boyfriend had allegedly stolen hundreds of dollars from her accounts while she was incarcerated. But returning to a court-restricted address without first verifying her release conditions with an attorney or the court was a legally and practically preventable error. The resistance during arrest added a second charge that would not otherwise exist. The phone call to her mother for informal permission was not a substitute for legal authorization, and the subject's apparent belief that it was reflects a gap in understanding of how court orders function. What she did right. She arrived with documented evidence of the alleged theft. She clearly communicated her circumstances, and she did not threaten or endanger anyone at any point. The deductions are not about fault in the broader sense. They are about choices that made a difficult situation measurably worse. 3 things stand out from this encounter. The first is the gap between signing a court order and understanding it. A signature on a release document creates legal presumption of knowledge, but that presumption can be challenged when the signing party receives no copy and no meaningful explanation. Anyone released on conditions should demand their paperwork before leaving the building and seek clarification on every geographic and contact restriction before going anywhere. The second concerns informal agreements. No private arrangement between family members modifies a court order. The only mechanism that works is a return to the issuing court and a formal motion to amend. Anything short of that carries no legal protection whatsoever. And the third is the right to medical care and custody. It exists, it is constitutionally grounded, and a person who believes it is being denied should state that clearly and on camera. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching. And don't forget to check out our second channel, Audit the Court, for even more police interaction and courtroom content.